course for criminal court practice, as you've heard. And if maybe, I don't know if the schedule shows, my name is Ccp, and I will be running through this course, criminal court practice, with you for the next 5 days. And my intention, excuse me, is to ensure that I don't give you what you already know in terms of what you've learned from varsity, but rather, as you can see, we are going to talk about what happens in actual practice in a criminal court. So our main focus will be in what happens in the lower courts, because that is where you are likely to start, your matters. So, ladies and gentlemen, I see someone saying Zuki should send the slides. I did ask her. She indicated that the slides were already shared. So if maybe you didn't get it, I would suggest that you drop her an email. It's very simple. Then she can reply by sending you back the slides. And I like to start the course with going back to the introduction, and basically the introduction of this topic of criminal court practice. Pardon me, I've caught a bit of a cough. I'm hoping it will clear. This season has not been kind to us, I think this is my 4th time getting it. So I'm drinking all sorts of things to try and clear it, but it keeps coming back. Yeah. So excuse me if I'm coughing here and there, but I'll try and just run through the program with you guys as much as I can. In terms of timekeeping, we are expected to start 5:30 and finish not later than 8:30, but we are allowed breaks in between. So the way I like to do things is, because we are working, even me, I'm from work, I haven't really had much time to breathe. So I do understand that bathroom breaks will be necessary. And my plea will be that we shouldn't be taking a lot of breaks. That way we can actually cover a lot of ground, and also we can, possibly adjourn a bit earlier than the time that is allocated. So I will at least be taking one break for this evening. If everyone is in agreement, I think, so I see the thumbs up. And the way we run with the program, we have the slides that will be shared with everyone. The session is being recorded, so you are welcome to request it. Because of load shedding, I understand that sometimes you may be thrown off, and it may take a bit of some time for you to get back on, and just to make sure that you you don't miss out on any important information. Please, I don't know how, but I see someone saying the slides are on the portal. I don't know about the recording. Maybe that one you may have to ask Zukiswa if you missed out on the session. But as long as you have the slides, you're not going to miss out on too much. That's just to put you at ease. If it happens that maybe you are disconnected maybe for 10 minutes or so. So because I move according to the slides, and even if you missed out you can catch up by just simply reading the slides. How I made the slides, I've worked with your manual, the one that is that thick booklet that the school has given you. I'm going to move according to the manual, but I don't necessarily make page references, but I follow the sequence as it is set out in your manuals. And I will urge you to maybe when we finish the class, go into your manual as well to just make sure that you haven't missed anything. But my intention is to try and cover a lot in these sessions that, yeah, if you're going back there, you're just rehashing what has already been covered in the course. And then the questions about exams, you know that the school will put you through different testing. So this part of the course will make a part of your exams. So the way I cover the syllabus, I also try to also give you a good, very good actually, very good preparation for the board exams. So we will do some examples also with the different scenarios that you may encounter in a criminal case. And I encourage everyone to feel free say to ask if you have any questions, if you're seeking clarity, even if you disagree with me, I will welcome you, because you know we all know that the law is changing, and you know you may be aware of something that maybe I might not be aware of. So just to share with us your experience and knowledge, you are very much welcome to do so. And yeah, let's not make a big deal about the slides. Zukiswa told me that she's not feeling very well today, so I can assure you before maybe Wednesday, hopefully, everyone will have the slides. So I will just remind her maybe tomorrow that it seems like a lot of people didn't get the slides. So don't worry, everyone will get the slides. Okay, so just for progress, interact, you know, in the sessions if you have anything, because I can't say to you, allow me to talk, and then as we are about to adjourn for the evening, you reserve your questions to the end. You might forget what you wanted to ask, and I may not having a chance to cover your questions. So feel free. If you see that maybe you are raising your hand, someone is talking. I think the house rules is that only one person should be, mic should be on for one person at a time. So everyone should make sure that you mute your mics, and you only unmute if you want to say something to me or to everyone here. So please, I know sometimes you may hit the button by mistake, but always try to ensure that your mics are off. So yeah. Okay, so I think we've covered the basics. And yeah, welcome to Criminal Court Practice. And we start by talking about the introduction, as I said, the general background to this very interesting topic. And I say it's very interesting because a lot of people like to believe that criminal court practice is for specific kind of people, or you know, as legal practitioners, there are those who don't even, you know, aspire or wish or even have a desire that one day they may find themselves, you know, in a criminal court conducting a case there. But I want with this general background to demonstrate that especially those who are coming from a corporate environment, there's just that general, I don't want to call it attitude, but it's just a thing that they may not have much interest in criminal court practice. But my intention is to show you that criminal court practice is not one way, that you would only deal with it only when you are dealing with criminal law. So with the sources that we're about to go through, I want to show you how everything can somehow link with the criminal law. And the first source of criminal law that I'm introducing you to is the Constitution of the Republic of South Africa. Many would have thought I would have said the number one source is the Criminal Procedure Act. No. Why I say the Constitution is the most important source in criminal law, it's because of the provisions of Section 35 that is contained in this Constitution, which deals with the rights of arrested, detained persons, sorry, and the rights to a fair trial. Oh, pardon me. Now, ladies and gentlemen, this Section 35, it's long. It has a lot of subsections, but it's the core, basically, of what we look at entirely when we are dealing with this course, because these rights of arrested, detained persons and those undergoing a trial, they kick in from the moment a person is placed under arrest, and their rights must be protected and observed even when they are taken into police custody, where they will be detained, and even when they appear in court, their rights must be, always observed to ensure that there is no tampering of the rights of these persons. So many people, they generally think that these rights will be raised once you are in court. But what happens on the street, before even you as the legal rep come on record, is also very important. That is the interaction between the members of, the police force and the suspect that they are placing under arrest. So these rights I will demonstrate through different ways how we apply them and show you why they are so important. So, because, ladies and gentlemen, the fact that the person has been caught red-handed, for lack of a better word, and they are immediately taken into custody with all the exhibits that have been found, evidence that is booked in to support them having committed the offense. If there's any suggestion to the fact that something has gone wrong with how their rights were dealt with from the moment they were, arrested or kept in this police custody, that can throw off the entire case. And that is how we say you can win a case based on technicalities, even though on face value, it appeared as if the state has a watertight case. All the evidence was pointing in a particular way to a particular person, and it appeared that there wouldn't be any loopholes. But the way this Section 35 can turn around the whole picture it can even throw out whatever evidence that could have been obtained at the scene implicating the accused person. And more of the rights of accused persons are still contained in the Bill of Rights, ladies and gentlemen. As you know, every person in this country, a citizen of the country, a foreign national, sorry, we all have rights in terms of the Bill of Rights that need to be protected. So when I mention the rights to equality, dignity, and privacy, those are just some of the few examples of the Bill of Rights that we all have as human beings, and they equally apply to the accused and, of course, to the complainant in a criminal case. Now, when we are exercising these rights, you are well aware as legal practitioners that these rights are not absolute. So we have to observe the provisions of Section 36 of the Constitution, which gives us a limitation clause whereby we have to ensure that there is going to be a balancing of the rights. So I did tell you that we are not just going to talk about crime. Already, I think you can see I've just been going on about the Constitution, but if you can take time and read on any case law, Google is our friend nowadays, not many of yes, Google is our friend. Just, while I'm talking, Google any criminal case that you want to check on any criminal subject. Just open that case, because Google has worked so well to put those cases. I'm talking for people who don't have like access to Utastat and LexisNexis and all that. So if you just look up any case law that is a criminal case, you will most likely find that how the case is reported, the way it starts out, yes, it will indicate that the issue was maybe about self-defense, or it was about identity, or whatever defense that, or whatever legal issue that was to be determined. But you will quickly see, before they get into the bone, the marrow of the criminal case itself, a lot of reference will be made to sections of the Constitution, the different rights that will be relied upon in that case. So you can expect that in every reported case law, there is going to be a mention of sections of the Constitution. The second source that we use in criminal court practice, it's the well-known Criminal Procedure Act. As you can see, the act is really an old act. It was made in 1977, but it has been, of course, amended a lot of times. But it is still the one codified source of legislation that we mostly going to refer to in a criminal practice in South Africa. It serves as our go-to guide, and there is other legislations related to that Criminal Procedure Act which have come out following the main act of 1977, like your Criminal Law Amendment Act 105 of 1997. That's also being amended, as the amendments come based on the necessity to make whatever changes that our legislature may deem necessary. So this particular act, it deals with matters where you will have a prescribed minimum sentence. And by this, I mean a particular offense. Before you can even start with the case, before the accused can plead to the case, whether they are pleading guilty or not guilty. For this type of cases that fall under this act, it is the duty of the court to inform the accused that please be warned that the offense that you are charged with is one of those that if this court finds you guilty, the court has already been prescribed a minimum sentence that it must impose. And this means if the court has been given this minimum sentence that it needs to follow, for the court to deviate from that minimum sentence, it is required that you must show that there exists substantive and compelling reasons that would warrant for the court to now deviate from that set minimum sentence. So why the legislature has come up with this kind of minimum sentences, it's because of the discrepancies that were happening between the different courts, between the different divisions with regards to particular types of, and here we are talking about your more serious offenses, whereby you would find that in a case of, for instance, robbery, pardon me, armed robbery, in one jurisdiction, you could get a court imposing maybe a fine. And if you go to another jurisdiction, you find that the courts are imposing an option, I mean, a sentence of direct imprisonment without an option of a fine. So because there needed to be a standard, a unit standard that had been set so that there's no situation where the courts are just using their own discretion to give sentences in those kind of offenses, then the legislature stepped in and identified those particular type of offenses that were very serious, and there was a need to make this uniformity, if you yeah, I may say, to set a standard minimum sentence that all the courts are supposed to follow in those type of offenses. Now, criminal law and sexual offenses and related matters is also another one. This one is specifically focused on sexual offenses. But these sexual offenses, some of which then can carry a term of life imprisonment. So you may be talking here about child rape, for example, because of what I've just said. If you went to one jurisdiction, this court will give you 5 years for rape of a child. If you went to another jurisdiction, then you found the court imposing very strict and stiff kind of punishment. So there are the examples there to show you that there is already prescribed minimum sentences that the courts are expected to follow. But it doesn't mean if there is a minimum sentence that is prescribed, as I've stated, they can't give a different kind of sentence. They have to be shown those substantive and compelling circumstances that would warrant for them to deviate from the minimum sentence. So those are not your ordinary personal circumstances of an accused. There has to be something extraordinary, out of the ordinary, something unique about your case, and you will state what makes you now to say the court must deviate. So the legislature, as I stated, it usually responds to the events which affect us as the community, and there would be, people who go on different platforms to vent their frustrations and anger and their wishes that they wish for the law to intervene when it comes to this particular type of events. And then based on these new events, for example, when there's an increase of a particular type of offense that is occurring, then you may have a new legislation introduced to deal with that kind of new event. I'm giving you here an example of gender-based violence, as it's an international problem, ladies and gentlemen. And the Domestic Violence Act is a clear example which has been made to deal with this type of offenses. And Protection from Harassment Act, your Children's Act, because these are the acts or the legislations that are targeting or aiming to give protection to our more vulnerable members of society, which is women and children. So those pieces of legislation, they continue to be relooked at based on the increase that is continuing of this type of gender-based violence. And I can tell you that Domestic Violence Act has already been amended. And with this amendment, you can clearly see that the aim is to give more coverage for those classes of individuals which were not necessarily included, and those type of acts of what qualifies as abuse that were not particularly covered by the Domestic Violence Act as it was introduced the first time. So you can take time and just read up on the new amendment for this domestic violence. But ladies and gentlemen, I can just tell you that this Domestic Violence Act is coming with a lot of changes that need to be made in the way the courts are operating and dealing with these kind of matters, to the effect that a person is going to be able to apply for these protection orders from the comfort of their own home. At some point, they intend to have these applications being done online. Therefore, it wouldn't require that the person come physically to court to complete the forms which are there at court. And this is bringing a whole new dimension, because if you say people can do this online, protection orders are urgent in nature, and it can happen that a complainant is sitting at 10 o'clock in the evening in their home, and they are, completing this request for an application of a protection order. And because they are urgent, it would be interesting to see how they will be addressed. But there's already talks that, there may be a need to extend the court hours, and to get, presiding officers who can deal with these matters after hours. So it becomes like bails now, you see, because it was only with bail applications that you could, make those applications after hours. But the way the new Domestic Violence Act has been set up, it requires that the courts would need to operate beyond, is it 9 to 4 or, yeah, beyond 9 to 4. So just for those who are interested, the impact of offenses perpetuated by people who have no tolerance for the gays and the lesbians is also one of the burning issues that are being closely watched. As in this country, we've had incidents where people were being, the members of the LGBTQI, I think the term keeps expanding, pardon me, my ladies and gentlemen, that I may not have put in all the, yeah, but this is something that is receiving close attention, and the legislature, I won't be surprised if they come up with something to address that. Like, for instance, I would have thought it would have been specifically maybe included under the Domestic Violence Amendment Act, but expansion there is to the elder, that is the more senior citizens, and also children. So things like spiritual abuse in terms of people practicing different faiths and things like that. But the Domestic Violence Amendment Act is not so vocal, though it can still be used by the members of the LGBTQI to, seek protection for protection orders as well, but it's not specifically mentioned there. So maybe a specific type of legislation is still coming, because this is still an ongoing concern that people are just being attacked for who they are, and there's just intolerance, and yeah, so we'll see what will happen out of that situation. The next source, we are still talking about criminal criminal court practice, ladies and gentlemen. Here it's taking us to another source, which is known as the common law. This is based out of the English law. However, there's been a lot of changes, as you are well aware, in our law. But when it comes to the principles of law of evidence in this country, when you are presenting evidence, we still follow the law of evidence, which emanates from the English law. So that is why we say the common law is still a source for us to can rely upon in a criminal case when we are dealing with issues of admissibility of evidence. Who is a competent witness, who is not competent, who is a compellable witness, who is not. So all those principles of law of evidence, they find their origin in the English law, and therefore that's one very important source of our law. Talk about hearsay evidence, the rules are there, and also to talk about the exceptions, of what kind of evidence will then be given exemption when the general principles are that, hearsay evidence is not allowed. If you want to make an exception to that rule, you follow Section 3 of, the law of evidence. So that's another very important source. You cannot get anywhere in a criminal case when you are in court without relying on those principles. I'm mentioning some, trying not to be too long on these sources. And please, I'm not saying these are the only sources, ladies and gentlemen. I'm just trying to show the links with other, topic, or rather other pieces of the law that will not necessarily be criminal law, but they can link up and find application in a criminal case. So next one here is textbooks, articles, and journals. Academic authors who are well known, like Snyman, who has written the textbook on criminal law that all the law students, you know it. So that is a reliable source that you can make reference to when you are dealing with a criminal case, because of the caliber of Professor Snyman and the colleagues who have been, well recognized in this topic of criminal law, because of the level of knowledge that they have in the subject. So you can, maybe for instance, you are dealing with a fraud case. When you want to mention the elements of the crime of fraud, you can use the definitions that are provided by Snyman as an example to say, this is how we should interpret this offense of fraud and the elements that we need to make sure exist before a court can make a finding of guilt. Law journals like your De Ribas, there, ladies and gentlemen, it's not professors per se, it's people who are in the field of law. They may be just your legal practitioners who can compile an article and research it so well, and you find that it's so well put together that you may actually wish to make reliance in your case based on that article. So, of course, you will have to qualify your author to show that they are legally qualified in terms of then being considered as an expert on the topic, but you can rely upon the articles that are contained in those journals. I didn't include here, ladies and gentlemen, case law, as you are well aware that there's cases that will take precedent over others. So yeah, that's another very important source. So before I leave this topic of the sources, I just want to say anything can end up somehow finding application or being something that can lead to a criminal case. It can be conducts that are happening in a boardroom, as we have seen with maybe directors of a company, maybe there's embezzlement of the funds of the company and the company is being defrauded. There is special courts that are set up to deal with commercial crimes. And if that is the kind of situation where this happened in some office where it was, something about whatever transactions that were being done there, it didn't, start out as what you would ordinarily expect, like a fist fight or a robbery, but something maybe like your white collar crimes where they can show a trail that there's paper trail to show how the funds were being moved from the business company, the business account to the individual account of the particular person, then that person will be charged criminally, even though they were doing what they were doing in a corporate environment. And now you come and this is a criminal case. So that is why there's courts that have been established to deal with those specific type of offenses, your special commercial crimes courts, whether it's tax evasion, whether it's your government officials who are doing bribery, corruption, eliciting, and funds from members of the public, unfairly. Yeah. So yeah, these are some of the examples of things that can happen where you wouldn't expect that it can end up in a criminal court. Yeah, but yeah, anything literally can have someone end up before a criminal court. Let's talk about, you this weekend when finally LC is done with her criminal court practice course after these 5 days, and you went out with your friends to celebrate your birthday, which you delayed until maybe Saturday evening. Unfortunately, on your way back, you are stopped by members of the police after you have imbibed. You've taken alcohol and they test you and you are found to have been driving with an alcohol level that is above the legal limit. You can be whoever you are. That is a criminal case. So I'm hoping that this little sermon that I have put you through, ladies and gentlemen, it has widened your thinking, that you mustn't just, when you think criminal law, you imagine that dirty guy on the robots, and you start thinking that could be someone who is an accused. Anybody, as you have seen, presidents have, been accused persons. I mean, yeah, anybody can be an accused. So I think it is important, if you call yourself a lawyer and you don't know criminal law, even if it's not your area that you practice in, my intention is to at least ensure that you are empowered when we finish this course, that even if maybe you are just dealing with, other types of the law, but if someone asks you a question that is relating to this criminal court practice, then you will be able to answer. Of course, not just for general knowledge, but it's also important, as you are well aware, that you will be examined at the school, and also before you can qualify to be an admitted attorney, it's part of your board exams. So yeah, it's good knowledge to have. So now, ladies and gentlemen, I'm changing gears and we're gonna talk about who are the participants in a criminal case. So often the cases would start with the police. Maybe somebody picks up a phone and calls the police and makes a report. And that is why they are normally going to be the first participant in a criminal case. And here, please, ladies and gentlemen, I say police/other law enforcement agencies. We will now discuss why do I make that distinction. So please take note. It is the duty of the police to maintain law and order, to prevent crime, and to investigate reports of crime. This leads me to my next question now. Who is a police officer? There is a definition that is given and discussed also in your manuals of a term of a peace officer. This peace officer is said to be the one who has powers. Now, when we say powers, because me, I've got little ones in the house, powers are very important to children. It means you can do something that ordinary people cannot do. This peace officer has powers to arrest, to search, and to make a seizure of items that are connected to a commission of a crime. Can we just discuss who are we talking about here? Now that I have gone as far as to tell you their powers. If you don't speak, I'm gonna start asking, pointing at people.
Sorry, just to understand, are you asking who is a police officer?
Who is a peace officer? I'm trying to answer that question of who is a police officer. One thing for sure, a peace officer is also a police officer, but because we've got different types of officers who are doing this law enforcement, who then is a peace officer?
I try this one.
Mm.
Can I try this one, ma'am?
Yes.
Yes, my name is Sam.
Hi, Sam.
A peace officer, I believe, is someone who has been appointed in terms of, let's talk about the police, in terms of the Police Act. If there is a traffic officer in terms of the statute that governs the traffic officers, or maybe some court officials who has been appointed in terms of the certain, I think, statutes surrounding their occupation.
I think from you, Sam, I had 3 things. I had a police officer, which maybe you will expand. I had a traffic officer and a court official. Am I right, Sam?
Yes, ma'am.
Okay. Others, what do you say? Keep in mind those powers. They will help you to quickly identify who is this person that we are referring to. Mark,
Figure out what we're investigating and who it's threatening.
Yes,
Yes.
yes, ma'am. I'm just gonna give this one a try off top of my head. Actually, it's just, I think, to summarize it, a peace officer includes a lot of officers who have authority, but let's say, we have a status, like for instance, we can commission, we have authority to commission, how can I put it? Like for instance, there's commissioner of people who are in that category of officials. I think this is, again, off top of my head. I've not been looking at this for quite some time. So that's different from a police officer. Also, there are police officers who are authorized to commission papers and stuff like that. I'm talking now, like for instance, the reservists don't qualify, in my understanding, as peace officers. But yeah, I think that's my limited understanding of a peace officer.
Okay. Thank you, Maliqole. Ma, is it Mulebogeng?
Yes, it's a little thing. When you say we must look at the responsibilities of arresting and searching and stuff, my first attempt is a constable. I'm not very familiar with the police stuff, but I would think of a constable when you talk about arrest and search, things like that.
The constable in the, I don't know if they have, I don't know the rankings also of the metro police, but are you talking about South African police constable?
Yeah.
Mm.
When I think of a person who can arrest, I think of a constable, unless maybe I'm not sure of their rankings as well.
Mm. Okay. Any other law enforcement officers? Because there is quite a lot. So
Yeah, sorry, Ms. Elsie, it's Richard here.
Hi, Richard.
Ah, yes. Yeah, a peace officer goes much wider than a police officer. If you go look at the Criminal Procedure Act, like we've done in our first years of studying, it refers to various persons. For example, a member of the correctional services will also be regarded as a peace officer. Also, the Minister of Justice can make regulations as to who are peace officers. And I like the way that you've put the slide that speaks to about, for example, other law enforcement agencies. If you look recently, the Minister of Justice has declared members of the investigating directorate in the NPA as peace officers, which is other law enforcement agencies like previously had the Scorpions. In terms of the amendment to the National Prosecuting Act to accommodate the investigating directorate that President Cyril Ramaphosa declared in his speech 2 years ago. So those guys are also regarded as peace officers, and it can include magistrates in your small towns and things like that. So thanks.
Thank you, Richard. I see Sandy, let's hand this up.
Oh, okay, yes, ma'am. I also wanted to add to what Richard has already said. I think the peace officers are the people who are working from these different law enforcement agencies. We talk of military police, SAPS, traffic police, and also municipal police. Those people are regarded as peace officers because they are enforcing the law in their respective areas. Thanks, ma'am.
Thank you, Sandile. Is it Nobubelo? Nobubelo?
Yes, can you hear me?
Yes, we can.
Okay, good evening. I would say a peace officer, basically based on the description that was given, that you have the powers to arrest, search, and seizure. I would say maybe 2 examples would be a sheriff and a police officer. So, for example, with the sheriff, they have the power to arrest as well. With collections or with the warrant of arrest that's issued, they have the power to search property. They have the power to take movable property for debt collection and stuff like that. And the police officer also has the same power. So basically, in order to uphold peace, yeah, that's what I think.
Thank you, Bulelo. Sulufelo?
Am I audible?
Yes, we can hear you.
Okay, yes, I just wanted to also add that it's all other law enforcement agencies that we have. And we also currently have additional ones, as you've all seen that the Premier has hired these Amapanyaza guys, of which when he was asked what regulates them, he also classifies these Amapanyaza people as peace officers as well, as their mandate is to also try go about preventing crime in the communities.
Okay, thank you, Tsulufelo. You can mute. See, the baby's talking at the back there. I think we'll take the last one from Mpho. Mpho is gone. Adam, you go.
Good evening. I think, oh, okay,
Mpho is still not audible. Go ahead, Adam.
Okay,
Adam.
I think it's Adam. I think a peace officer is any person that is appointed under Section 334 of Criminal Procedure Act.
Tell us, what does the section say? You are now playing legalese with us. Tell us.
It's actually a power that is being empowered by a Criminal Procedure Act for a specific person to perform a certain duties in protecting or conducting any law enforcement duties.
Okay. Well, I like the way everyone is thinking, and I'm very, very happy to see that people are trying to expand their thinking, not to just stick to the normal South African, police services. So in terms of that, before I give what I want to say now, please, with the law, there's changes all the time. So it is very important that we keep abreast with the changes as they are happening, because it is just a lot. So it is important that as we leave this course, should you have a case that you now need to determine whether the officer who effected the arrest was a peace officer or not, please take time to read up and make sure that you are not just assuming that because they carry at the end of their name or they bear that title of officer, that you would assume that they should be having that power, rather qualifying to be considered as a peace officer. So the original position was this: a peace officer was clearly is meant to be the members of the South African Police Services, SAPS, and the members of the military, South African National Defence Force. But as you have mentioned, all these instances where there's developments because of the high crime rate, to ensure that there's enough coverage of the law enforcement in our areas, expansions keep on happening. But the original position is that it was meant to be SAPS and South African National Defence Force. Now, also because of the emergence of the metros and the introduction of the metro police, who happen to have more coverage in terms of the areas that they're more visible than some members of the South African police. They are working hand in hand with the police. So you need to ensure that when you deal with a case where a member of these other law enforcement agencies has effected the arrest or the search or the seizure, you need to ensure that they actually qualify to be a peace officer. And how do you now make certain that they now have these powers of being considered as a peace officer? It cannot just be assumed that you are a member of Metro Police. Automatically, of course, their day-to-day, remember here I spoke about the duty and I spoke now about the power. Those are two different things. All law enforcement agencies, they have a duty to maintain law and order, prevent crime, and yeah, but it's not everyone who qualifies for this title of being a peace officer. And I'll tell you with a clear example of the Metro Police, because you see that duty of the police, it says they also have a duty to investigate reports of crime. Yes, they may be the first point of call on the scene, but they don't have an investigative unit in their ranks. Like with the police, South African police, they have a detective unit which is in charge with investigations of the reports once a case has been made. So you need to check. It's a fine line. It's a very fine line. But what I can also tell you will assist you to determine whether they would be able to effect an arrest, search, and seizure. Normally, they will have a written authority. For instance, if they are going to do a roadblock, there's an operation that they mean to do at that scene, at that corner of whatever and whatever road. So we know from this time to this time, they will have a written authority at the roadblock, which you can request to see if you are doubting that they are legally authorized to conduct that operation. So because, like I'm still talking about the Metro Police, they also don't have detention facilities. What would happen is that if they are the first ones on the scene, they would be able to apprehend. I didn't say arrest. Well, English, you can help me for very light words that will maybe help us not to be caught up in this arrest thing, because arrest is a very, 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 contentious issue. When now you are deciding whether this person had the necessary power to effect an arrest, because if it is found that those officers did not have the authority to effect that arrest, it will also do what we spoke about, renders the whole case, to be thrown out because of an unlawful arrest, and the state will be sued for them having effected an unlawful arrest. So you have to check each case. Please check. Don't assume that because they are wearing uniforms, they are carrying guns, that, of course, because that is like what ordinarily people think out there. I've been told, I've never seen it, that apparently there is some written document that was given to some members of the Metro to be going around with on a day-to-day operations, not this special, like a roadblock, like when they are just doing their random up and down patrolling. I was told, I haven't seen it, I was told by someone that apparently they've been given something that is in writing. So you are, welcome to ask them to show you what kind of authority they have. But as it stands, they don't have it automatically, but that authority can be granted to them by extension, as I can't remember who was talking about, you know, the extension of that policing authority to the members of these law enforcement agencies, because SAPS cannot reach everyone. And in most instances, they are the ones who are there. So please check. I'm not saying all of them have it. Just check what they have. You are entitled to request them to show you the authority that they have. So while still talking, I've noted you, Zandile and Pretty, I'm coming to you. Now, that definition, I said it was meant to be without question, SAPS and the Defense Force. Without question, there we don't even ask for a written authority. We are clear that they are peace officers. There's instances where this authority gets extended to other agencies, like in areas where by the borders, where there's a lot of like the national parks, those officers who are, is it game rangers? Yeah, what they are called. So where they are operating, because it's in the outskirts. Sorry. Sorry about that. So your game rangers, I don't know if that's the term, but the ones who are patrolling and keeping a watch that the poachers don't come there and poach the animals, they also, on a daily, they move around with a written authority. They can effect an arrest there and search and seizure without question because of their location. They can't leave a poacher and say we are calling SAPS who is 400 or 500 kilometers away. So you need to check when you encounter these law enforcement agencies in order to know that they have the necessary authority. Okay, Zandile, let's hear you. Did you fall asleep on us, Zandile? Mdaga. Okay, Pretty Mahumane, your hand has been up.
Yes, I just wanted to get clarity in terms of the community forums that we have in these locations. Where do they fall in? Because sometimes they would arrest, not necessarily arrest a person, but they will capture a person and then hand them over to the police. Like, where do they fall?
So CPF, I can also put them in the same category as security personnel, the security guards. They are all over the malls, the estates. They are doing access control. They are inside the shops. They are there witnessing commission of crimes, whether it's robberies or shoplifting. I'm adding to Pretty's question. What do you say about them? Malikole?
Yes, I just wanted to check if, two things. Like on the peace officer part, if I'm understanding correctly, is that it includes almost all the law enforcement agencies, or but at the same time, they must have a certain authority or certain rank, if I'm understanding correctly.
It's not about rank.
And
it's just about written authority to extend their functions to be qualifying them to do what a peace officer is allowed to do. It must be in writing.
Yeah,
But
so
if
do
they,
you
if they
reckon
don't
that
have
now,
it, then whatever they've done,
do-
it's unlawful.
but do you reckon now the ones who are given authority on a daily basis do qualify as peace officers, or they just get a temporary authorization for that time or that day?
I
Because
know
my
for
understanding, yeah,
sorry. Continue.
yeah, what I wanted to understand is that you mentioned that there are certain police officers or police agents or law enforcement agencies that get given an authority for a specific period. Do they automatically then qualify as peace officers, or they just given that authority for that specific moment to kind of like carry out the activities that they wouldn't otherwise have been authorized to carry at that specific time because they're not qualifying as peace officers? Or do you mean that once they've been given that authority for that day, they now qualify as peace officers?
If they are given an authority to do a roadblock, it will be for a specific day, for a specific time, for a specific location. So once that time has expired, and also a very senior officer of the metro must be present at that roadblock, so that when they find someone who is to be arrested at the roadblock, South African police officers will also be there to hand over that person to the SAPS to effect a lawful arrest.
Okay.
That is the norm. But I'm not ruling out, because people are talking. That's why I said what I've been told is something I haven't seen. And even from my colleagues that I'm working with, we haven't seen that so-called authority that allows them to, like, you know what we are concerned about here, basically, it's those random stop and search. You know, the ones where you are just driving and they are just by the side of the road. There's not even anything to indicate roadblock. There is just a vehicle and uniformed officers. Those are the ones that become a thorn when we come to court. You see.
Okay.
Veronica, do you want to help us?
There was also another comment on you had a question about the CPF and the like.
Yes,
Whether,
I
yes.
asked about CPF
Yes.
and security, that security guards.
Yes.
Can they? Yeah.
Yeah, just when I was saying, I had two comments. Firstly, the peace officer and that part. So again, this is a theory from my theory knowledge of this. My understanding is that the general public as well is entitled to, not necessarily, I don't want to use the word
Citizens
arrest.
arrest. Citizens
Sorry?
arrest. We are talking
Yes.
about the citizens arrest.
Yes, I'm saying I would assume that also the CPF is more like on a different level as if the general public is entitled to arrest someone when they see they're doing wrong thing, and then the CPF is much more now on a different level. They would also have a similar type of authority to arrest as well. But I'm not speaking from an authority or legislation or piece of legislation of anything. But I think they should have that authority as well to arrest and kind of like hand over to the authorized officials.
If you are still handing over, then it means you don't have the power. This power of a peace officer cannot be cut and chopped and say only you can effect a lawful arrest, but you can't effect a lawful search. Do you understand me? These powers, as they are, they must be able to be exercised in full by this officer. So
okay, then this brings us back to the to my first comment, in which is like, for instance, the guys who are given an authority on paper to go and arrest and then hand over, which means then comes back, even if you've given that authority for that day, that means you don't qualify as a peace officer. You just been granted some type of authority for that day. If speaking of like now, and you know that if they hand over, that means they don't qualify. In which case, the very guys who are given just that paper for that day, they also don't qualify as peace officers.
Yes, but listen to what I'm saying. When you meet up with this police at the roadblock, you cannot refuse to be subjecting yourself to an arrest because they have that written authority for that day. You cannot refuse. The situation becomes different with those random stop and search because there is no written authority under normal circumstances, as I know, and that is how we've been challenging it in the courts with my colleagues and I, that then with a random stop and search, you are expected, obviously you cannot let a criminal get away with a crime. You can apprehend, but you cannot place them under a lawful arrest. Once you are able to get them to be with you at that place, you are expected to call on the members of the South African police to come and take over, to effect a lawful arrest. And then they can take them by searching and then seize whatever they seize, ending up putting them in lawful detention. So the CPF also, I think it's answered by my answer to say, if members of the CPF apprehend someone who is committing a crime, it is still expected that members of South African police must be called to effect a lawful arrest. And those are just ordinary citizens. So like you and me, I guess you are answered. Read up also on a lot of cases that are reported on the security cluster. They've been trying to fight for that recognition in the courts a lot, ladies and gentlemen. So take your time and read up. If you meet up a case that is not ordinarily SAPS, read. That's where you'll get all your answers. We can debate the issue all we like here, but the standing position is these powers are not to be exercised by partitioning them and say, okay, you can only arrest, but you can't search. Once you have the powers, it means you can do everything. That is the position in the law. So that is why I said focus on those powers. If they can't do everything as per the powers, then it means there's lacking something there. Then you can't, that kind of evidence, if they try to present it, it can be challenged in the courts. So please lower your hands, ladies and gentlemen, so we can move on. The rest you can read more in your manual. This topic of peace officers is extensively covered in your manuals. So you can just look it up. But I just wanted to make you aware that not everyone who's wearing uniform is supposed to arrest. Okay. Prosecuting authority is the next member who is a participant in a criminal case. The prosecution are called dominus litis, and this implies that they have a power to make decisions on whether to prosecute a case or not to prosecute. This is a power that they can exercise without anyone, even the courts cannot interfere with this power that they have. If they say we are not proceeding with this case, it's the end of it. You know, if they say we are prosecuting this case, it's the end of it. So you cannot use the court to try and interfere with this power that they have as dominus litis. Yes, like any power that is there, you will find that at times people, they go too far, ladies and gentlemen, in exercising the power. And that is why we have a lot of cases where the state is being sued for malicious prosecutions, yeah, because at the end of the day, you have them being the ones, once the police have done their job on the streets, they bring the docket to the prosecutors. They have to make a decision whether they are going to take the matter forward or not. So the police, they may be acting out of adrenaline on the street and emotions, but it is expected that once the docket is before a prosecutor, they are legal professionals. They must make their decisions in a sound and sober senses. So if you find that they are being malicious, they will be sued. And also I discuss this trend that is common, that the police will first effect an arrest and then investigations will happen at a later stage. Zandile, please lower your hand. I guess you forgot. So this presents a challenge, that there's lawsuits that are going to be made against the state emanating from those unlawful detentions and unlawful arrests. So how do you determine that a case would qualify to be one where you can make out a case for unlawful arrest? Remember, or for unlawful detention, you still have to show that as the decision was taken to proceed with that case under those circumstances that were questionable, somebody ignored all the red flags and decided to proceed with the case and ignore the red flags and acting in such a manner, it was because they were being malicious. So when you have an ordinary case, you will obviously, at the first available opportunity, try and show the state that, look, you're not going to win with this case. You don't have sufficient evidence. Whatever challenges that you may see will be hampering them in their ability to successfully prosecute the case. You will make representations or whatever written, requests for them to withdraw the case. And it is better if they're in writing, because then they will also respond to you in writing as well, so that you have a record to show that you did try by all means to show them that that case, they shouldn't proceed with it, but all your pleas were just blatantly ignored. Now, the state witness is also part of the state case. Generally, you as the defense lawyers are not allowed to consult with them unless you have permission of the prosecutor, or you ensure that when you do consult with a state witness, the prosecutor should always be present during that interview. And here we are trying to avoid a situation where you may be later accused of having influenced the state witness not to cooperate with the state, and then they turn out that now they no longer want to testify against the accused, or they now deciding that they don't want to proceed with the case, they're asking for the case to be withdrawn. So if you are doing this openly, at least you hope that you won't be accused of such. That kind of a situation is rare, but if it happens, you make sure that the prosecutor is present. Defense witnesses are yours. So you consult with your own witness and just for your own safety, we advise that when you consult with these witnesses, the same way you will do with the accused, consultation statement must be made in writing, it must be signed and dated, because you don't want a situation where the witness will turn around and say, I never told this to the lawyer, or yeah, basically turning around and saying that is not the story that they told you. If you are called upon to appear maybe for a disciplinary hearing at the LPC, ladies and gentlemen, you will have to bring your file, you'll have to produce your notes to show that these are the notes that I took down during the consultation. This is where the witness signed and the place and date where that consultation took place. And it may be your witness, like I say, it's a defense witness, but you still need to ensure that you protect yourself, ladies and gentlemen. And in cases where you establish that there is going to be a defense witness, for example, an alibi, it is very important that you, not only with an alibi, all witnesses, but with an alibi, you go the extra mile to consult with them thoroughly, because the prosecutors, they will deal with their evidence extensively, and the aim is to try to discredit them, to show that they are maybe lying to protect the accused. So you have to ensure that you really prepared that witness for what they will face when they go to court. Remember also to put your client's version to the state witness. On this one, ladies and gentlemen, you'll do that when you find it is necessary. If, for example, the state witnesses have testified and they have not in any way implicated the accused with the commission of the offense, then there may be no need for you to cross-examine, and also no need to even put any version. You can just, if you feel like, you can just say the accused denies the allegations, and really a bare denial is just a bare denial. But there will be times when you hear the testimony of the witness that this witness is placing the accused at the scene. Now you will have to put a version to that witness so that you can get a reaction from that witness. And also, please, we caution that when you are consulting with this defense witness, make sure that you don't do it with the witnesses being together. We don't want to avoid, we are trying to avoid influence on the defense witnesses as to what they should say. Many times in court, was especially under cross-examination, because that's where the heat is on. We find when the witness is now, being grilled literally, and the heat is too much, and they're being asked, why are you saying this? Why are you saying that? Then they will come out and say, no, I actually didn't mean to say it in this way. It was actually my lawyer who advised us that we should, testify in a particular way. So please ensure that you separate your witnesses when you consult, so that you can get their own story or version of events. And then if there's no issues of conflict or whatever, there's no need to bring back all your witnesses together to deal with their versions of what they will be telling the court. But reduce it into writing, always. The accused and you as the legal rep is the next participant. And this, ladies and gentlemen, we say that you will find that the client or the accused, you find that they are a lay person in terms of the law, which is why they approach you as the lawyer to be their legal representative. And what we mean here is, because of Google being our friend, everybody assumes that they can just type in a few words and they know the law. The fact remains, your client may be a professor of whatever field that they are, a specialist in whatever, subject matter. But if they are in court, the legal expert, the one who knows the law, it's you as the legal rep. So I hope that tells you that you know also the law that you are talking about, because you have now the confidence of this person who's very smart. They may be even a genius in the record books, but not just in the law, So you have to make sure that you are well, knowledgeable, and you know your law very well, so that you can be able to effectively represent your client. So please note here, I say there is a presumption, because you are considered as candidate legal practitioners, right? Candidate attorneys. Once you place your name on record, even your name appears on that charge sheet, that you stand up there in court and you confirm that I am here from so attorney and I am appearing on behalf of the accused. You as the lawyer, you are expected to have the necessary legal expertise. Please take note that issues of inexperience and negligence on the part of legal practitioners does not protect you from facing the music, because that can affect your client and the outcome of their cases. You can take time and just look up the case law where the courts dealt with the issue of inexperience on the part of the legal practitioner. It cannot be excused. Unfortunately, if you feel ill prepared, or you're not ready, because things happen so fast in court, remember you are supposed to be operating under your principal. So when you are still doubtful that you are equipped with the knowledge that is expected of you, look at it. They say you are a legal expert, and this is the first time you are in court in your life. But your name being on the charge sheet, the court looks at you as a legal expert. So how do you cure this issue of inexperience and you being found to have been, considered as being negligent? Of course, preparation in advance. And what you can do once you are there, because unfortunately I've heard of instances where people will just be told, please take your gown and diary and go to court and go and postpone a matter. And you are told, don't worry, it's just a postponement. But when you get to court, a lot can happen. Lots of questions can be thrown your way by the court, and you may remember you were just caught off guard. You just came that morning. You told yourself that no, today maybe you are drafting some whatever that you are drafting, but now you are told, oh no, the one who normally goes to court has taken ill. Please fill in and just go and appear quick, so that at least there's someone standing in. If they ask you too many questions, just tell them that you are standing in and just postpone the matter. Tell them that your colleague is going to come back in a week's time and they can postpone for the next, court date. But unfortunately, you come before that presiding officer who is going to ask you that question that you did not ever expect, because you didn't even have the full knowledge of the case in your hands, because it was just thrown on your lap as you walked in and they said, please rescue the situation, just go and postpone. It happens. I see some laughing faces. It happens a lot. So, that could be even a day where, for instance, the issue of bail could have been considered. The release of an accused was compromised because you were ill prepared. You didn't know what you must say, and you didn't want to show your principal that you are a chicken. So you decided to play, bold and just dive, Listen, ladies and gentlemen, okay? People are laughing, maybe because I sound funny, but I don't think I am, because I know these things, they happen. What you do, ne? When you get there, of course, you want to prove yourself to your principal. Take the file. Hopefully, there is something in there except a clean paper, because some files are just having the names of the, the client and their telephone number, and there's just a clean, paper inside the file, which means no consultation has taken place. So there's no notes. Yo, guys, it happens. And you now have to go to court because you are told, no, don't worry. It's not for trial today. Just go and postpone. When you get to court, first thing, find the prosecutor in that court. Before you even talk to the accused, find the prosecutor. Tell them, listen, my name is LCC from this firm. This is my first time in court today. I'm told there is a matter of this on the roll today. Can I please, if it's not, a problem with you, can I please see the docket so that I can have an idea, or at least let me see the charge sheet that is filled in, the annexures, to know what is the charges that this person is faced with. And then they will decide, because remember, with the access to docket, it's quite tricky when it's still at the bail stage. So hopefully then they may, even you can ask them, can you tell me what are the, the allegations that this person is facing? And what is the matter here for today? Okay, now that they've told you, take that charge sheet, read it to know how many times does that case come before court, and what is it coming there for on that particular day. And then you tell them, okay, I see the matter is last time it's coming to court for further investigations. Ask the prosecutor, what investigations are you doing? Are there still any investigations still outstanding, or are you ready to set the matter down for trial? Get that information quickly before the court starts, and then you ask them, then please let's go to the chambers, obviously, to introduce yourself, and then you can now go to your accused, get whatever information that you can get. And if there's an issue of the client being in custody, automatically expect that you might have to deal with the issue of release. So there you will need to know the questions that you need to ask the accused also. But we will come to that when we are talking about bails. But yeah, the idea is, if you don't know, ask and hint, of course, that this is my first time. Even when you go and introduce yourself in the chambers of that presiding officer, throw it in somewhere in your introduction to them that this is actually my first time, in court, my first matter. So yeah, I'm quite excited, but still nervous a little bit, So you are making them to be aware of how far and how much they can expect you to know. That is how you handle such issues. Now, once you are in court and the court is throwing questions at you, you don't know the answers, don't just answer, shoot from your hip also. If you're not sure, remember you are there on instructions. If you don't know, tell the court that I need to take instructions on this question that the court is asking. Can I, either approach the accused and ask, or maybe during the tea break, then approach the accused to answer all those questions that the court wants you to answer. And if you're still not sure, your principal should be on speed dial. So you should be able to quickly drop a WhatsApp or a quick message to them to say, listen, this is what's happening. What do I do here? They will be able to give you guidance. I'm just talking for those who actually find themselves drowning in many instances because they want to, once you are wearing the gown, that black gown doesn't come with knowledge. You still have to learn. So if you don't know, you can ask for indulgence, for you to consult your seniors. Don't act like you know, you don't know. It's not a crime. If you don't know, you need time. Yeah. Thank you for the hands. So that's how you cure the issue of inexperience. Of course, you don't do it in an open court where you look like an idiot in front of your client who's paying you a hefty money. So you play it professionally like that. You just say, you know what, I'm gonna need some indulgence from the court to give me a few minutes that I need to, consult with my senior on some issues concerning this matter, or I request, this matter to be stand down so that I can be able to, have the answers that the court would like me to answer when we resume. Then you are covered. That is how we try. So you learn trial by error, but hopefully you'll survive. Conflict of interest is the next topic, ladies and gentlemen. So it happens, I'm gonna adjourn after this slide for a few minutes. Maybe we take 10 minutes or 15, stretch a little bit. So conflict of interest is a very, very serious one. Ladies and gentlemen, the conflict can arise between the lawyer and the client. And when there is when there is this conflict, you as the attorney, you are ethically bound to withdraw from that matter. Why? Because it will not be possible for you to act in the best interest of your client. So how do these conflicts come about? It can arise in cases where there is a disagreement between you as the attorney and the client concerning the instructions that they give to you as the lawyer. Sometimes the clients, they give conflicting versions. And this happens often where you may meet them, for instance, at the police station, right? And then the matter goes on. Unfortunately, you are not able to secure bail. And now they are in court and they are now being further detained in a prison, no longer at the holding cells. So the people at the holding cells, they will obviously have an influence, maybe to some extent, on the accused, because when people are in trouble, they like to share their troubles, Before you come along, they've told those who are with them in the cells, this is the story, this is what happened to me. And then you come on board and you ask your client to give you their version of events, and you get the version. Now, once you are in court, they are now remanded to prison. there is a population there, a whole community of prisoners who are also highly experienced when it comes to their encounter with the law. They've been brushing up against the law from the days when they were not even having teeth. They were maybe having 1 or 2 teeth in their mouth. And they are now fully grown adults who have a record to show that, yeah, they are knowledgeable with things of the law and the courts. So those kind of people, they like to share their experience with the newcomers in the prison. So when this guy comes in, they will ask him, hey, what are you in for? And then they will tell them, I know, I'm here for this. They'll be like, yo, cancel. You cannot go to court and tell the court that story. My friend, you are going down. With that story, you are going down. Remember, that was your initial instruction. So now you meet your client for the second time. You are now preparing to go for trial. And you're now confirming the version as you knew it. And the client is bringing up all this new information that you have no idea where it came from. You look at your notes that you have and what they're telling you, you even confront them, you're like, but this information is completely new. How come? So now you are left with 2 versions that are conflicting. Which one are you gonna go forward with? Because you cannot erase what was said in your ears. You cannot erase it from your memory. So you are conflicted. That is how those versions that develop with time, after they have been there with the senior counsels, as we call them, in custody. So you now have to decide. Are you still able to effectively execute your mandate? I don't think so. Because which story now are you going to go with? The first one, are you going to somehow miraculously forget and decide now this is a better sounding story? Remember the rules of ethics. You are an officer of the court. You don't mislead the court. You are there, yes, to legally represent your client and act in their best interest, but that shouldn't come at the detriment of the smooth running of the justice, the course of justice. You understand? So you're not there to help them to get away with a crime. You are not there to cover up. You are there to take instructions. And if the instructions don't make sense to you, they are conflicting, they are whatever, you have to withdraw. In other instances, there may be more than one client involved in the matter. And when you consult, which I advised you, always do it separately, even if all of them, they are your clients. They now start to implicate each other for the commission of the offense. Obviously, it will become a challenge that you as the lawyer have to cross-examine your own client, which is not ethical. So you may then have to withdraw from such a case because of this conflict that has arisen out of that situation. Okay, so let's talk about in court. All along, you've been coming to court, you're on record, fine, everything is going all right. And then boom, here is a conflict. You've been the one busy fighting postponements and saying, no, this matter must proceed now, miscarriage of justice, yeah, what, unnecessary delays and whatever. And then, boom, one day now you come up and you start telling the court that you and your client, you have, hit a, a snag, you're not seeing, eye to eye with your client, and you are now faced with a conflict. What can you do if the court says, but say you've been coming along here all this time, you know, we actually ready that the matter will proceed today for trial. The witnesses are here, you know, others have been flown in from far. They've booked hotel, the state has booked hotels, you know, to secure the attendance of those witnesses in court. And here you are now informing the court that you have a conflict with your client. What do you say when you come out of the record? How far can you go to express the conflict between you and your client? You cannot say things that are going to damage how the court will view the accused. Even if the client is giving you conflicting versions, like now, he's lying to you at this point, according to you. You cannot stand there and say, the accused is lying to me. You cannot do that. Because remember, when you get off the record, the accused still remains an accused in that court. So you cannot influence, you know, how the court will view them, because they are, you know, entitled to be received, to receive a fair trial, and they should be viewed, you know, as innocent until proven guilty. So whatever differences that you have, you cannot explicitly express what those are. You cannot say now he's keep on changing his stories. I don't even know which one to go on. No, you simply tell the court that you were prepared that the matter would go forward with you as the attorney of record for the trial. However, you have hit a snag in the instructions that you have from your client, and there is a clear conflict of interest at this stage. You are duty bound to ethically, you know, not be the attorney of record. You have to withdraw. You just say that. You don't have to say specifics of what is the conflict exactly. You please watch out for this, because I've seen some presiding officers trying to somehow, I don't know whether it's in the spirit of trying to mediate, you know, so that the matter can move forward, that they will say, accused, what is the problem? Why can't you cooperate with the lawyer? And then they will say, what is really the problem? You know, they don't have to do that, because that may lead to you disclosing information that can be damaging on the character of the accused. So just clearly state that at this stage, there is no going back. You are withdrawing from the matter, and it is because there's a conflict. The accused must be informed of their rights to choose another attorney, and somebody else will come and deal with that client. That's what you say. Okay, let's take our break. How does 10 minutes? Let's take 10 minutes. We resume 1934, and then we work towards wrapping up for the evening. Thank you. 10 minutes. Hello, we resume. Ladies and gentlemen, the next topic I wanted to touch on before we go on with the next section of the course. Cindy.
Hi, lecturer. Sorry. In the previous slide, I heard what you said for reasons of wanting to withdraw. But I've seen in practice some of the attorneys, without wanting to explain too much, I don't know if it's ethical or not, they'll say we're withdrawing for financial reasons or lack of financial instructions. Is that a safe exit card without disclosing too much?
It's not good actually, because if you've noticed, before the matter gets to trial, there's going to be ample opportunity for you to have time between you and your client to iron out the issue of funds. So for instance, if maybe you were initially instructed to deal with the bail and the client wants to retain you going forward, and then there comes a lot of remands that happen due to investigations, that is where normally a lot of money gets drained. So I think I'm gonna talk about the fee structure a bit, but I can just say that there's a lot of presiding officers who have not taken kindly to be informed that you are withdrawing due to funds. Because they are of the view that that is something that does not concern the court. It's your fee agreement happens out of the court. Why should you bring your relationship between you and your client to affect the smooth running of the court? So that is the attitude of the presiding officers. So you having to withdraw because the client cannot afford your services is something that you should have covered with the client in the initial fee agreement to ensure that the client will be able to retain your services. And at the earliest available opportunity, you need to indicate that, look, this may be my last appearance due to the fact that I'm only instructed up until this point. That is what you should say. You don't have to say the client has no money to pay me going forward. I mean, no, you can just say I've only been instructed up until this point. So outside the court, then you will have to tell the client that, look, if you want me to come back, pay me. If you haven't paid me, I'm not coming back. And don't disappear. Because if it happens that you did not excuse yourself from that record, basically you did not withdraw as the attorney of record, you are going to be expected to be there on the next appearance. So that is why now the presiding officers will be irritated when the matter is before court, your client is there, the state witnesses are there, and you are not there. And now the matter will be stood down because you are expected to be in court. The court will instruct the accused, go and call your lawyer. And then he will go and call and come back. What's happening? He says he's coming. Okay, finally the lawyer shows up. Ma'am, sir, what's happening? You are on record here. The witnesses are here. Why are we not proceeding? Now you come with that one. No, you cannot set a matter down for trial if you have not been placed in funds. In fact, lots of presiding officers, they report lawyers who do that to the LPC because that is something that should be covered from the outset. Sorry, from the outset, and it happens outside the court. It's not the court's business that your client cannot afford you. You don't bring that dirty laundry into the courtroom. Basically, it's dirty laundry. It doesn't belong in the courtroom. When you are there, you've placed yourself on record. you tell the court you are ready to proceed. If there's an issue that you foresee, because of course you might have, remember in your fee agreement, you may advise the client that, okay, per appearance, this is how I will be charging. And if it happens that the matter is dragging and dragging, I will have to adapt, obviously, the fees. You give an updated, account to the client so that they can be knowing how they are, paying you and how. But often, I will tell you that happens with these attorneys who are operating from the boot of their car, because people, they don't want to be, professional. They are just collecting instructions from the court cells through some dodgy guy who is there, collecting clients for them. And then, yeah, quick, you are now on record in court, and you haven't established whether this client will be able to fully afford your services. So you cannot. In fact, I've seen presiding officers who force those attorneys to proceed, and they will say, no, I'm not going to postpone this matter any further. You should have ensured before you confirmed, because before the date of trial comes, you stood up, you confirmed that, yes, this matter may be set down for trial. Yes, I will be ready to proceed on the next occasion. So now come the date when the matter must proceed, you are now saying you are getting off the record. That's very unprofessional. Okay, it shouldn't happen.
Thank you. Thank you.
Okay. So transcribed records is another challenge that we often get in the courts, because you find that when you send these records to be typed out, the transcribers will come back with a report saying they cannot make out what was being said in court. The recordings are inaudible. In the past, they used to use some tapes. They will say the tapes are not complete, and the situation can be so bad that you end up at times needing to do a reconstruction of the court record. And here is another challenge again. What if you were not the attorney who dealt with the trial? You are only coming on at a later stage, and the one who actually dealt with that trial is not from your firm. You don't have any notes. They are not traceable anywhere. You don't know where to find them. And as you know, some files may be very old. They may have been disposed of, So especially this issue of reconstruction of the record is a very big problem for matters that need to go for appeal. So at times, you may actually find yourself in a situation where you are left with no choice, because you were not there. Your client was there when the trial started and proceeded, but they are lay persons. They were just listening with their ears. They did not take notes. The prosecutor at times also, they zone out when the people are talking too much there in court. Plus, those chairs in court are not very comfortable. You will see them busy swinging side by side on the chair, irritated. They want to go to smoke, and this witness is just going on. So actually, they not taking notes. Actually, even the presiding officers themselves, we've seen them napping on the bench. So I'm mentioning this, that it's a reality, it's a problem. Everybody knows in court, you all have to make your own notes, but the situation happens that you may not have the notes. If there are any notes, you may find yourself having to rely on the notes of the presiding officer. And when somebody is making notes, they are making the notes for themselves. They're not making them with the intention that they may be called to produce that notes to be used to reconstruct. They're just making notes for themselves to recall what they think is need to be important facts that should be, so they can use longhand, shorthand, whatever. So those are the realities. A lot of appeals are moving slowly because of these challenges, because another thing is with these inaudible tapes, it's because people assume, I guess, that because we are in court, we are so formal, people have to be prim and proper. So all of a sudden, their voice will just be so down because they're trying to be, it will be so low that I don't know, maybe they believe that it's being professional or what, it makes them look like, I don't know. But I've seen a lot of times presiding officers battling to hear what the attorneys are saying. You know, you will often hear them making you to repeat what you just said. That should send a message to you that you are not audible enough. That should tell you that, remember, everything that happens in court is being recorded. If somebody who is right in front of you is not able to make out what you are doing, I mean, what you are saying in court, how is that transcriber supposed to come up with a full record? So please, you know, raise up your voice. And I know it may be a nerve-wracking exercise to be there, especially when you're still new at it. But as soon as you find, you know, your feet in the courts, please make it a point that when you speak, you are audible enough, because also that goes towards your confidence. It may actually even intimidate your opponent who's sitting right next to you, who's still shaking in their boots. When they see you standing, you know, upright with your chest out, stomach in, voice pitch, boom, come out. And they're like, wow, this lawyer knows what they're talking about, you know? So it's all strategy. It's all about appearances in the court. It's all a performance. In court, we perform. So how you present yourself, it's not just about the instructions that you got. How you put the instructions that you've been given across. Your strategy also goes not about the law, but also how you present your case. I'm not saying be the loudest guy that, you know, but I'm saying it also goes to show some confidence, and they will start believing that, maybe this lawyer has a case, even if you know that when you're just taking a chance. So it helps the record. That's the point that I'm making. And you may actually be lucky also that somebody may actually shake, because we are all trying each other in court. We don't know who is who in the court. So the more confident you appear, not arrogant, of course, please, because it's a fine line, but the more confident you appear in how you don't have to be cheeky and rude, you know, but yeah, it's all about, I think some of you did debates somewhere in your school studies, somewhere where you did, but I know that there's a course that you're gonna do, don't worry about it. In the school here, they offer litigation technique, so you're gonna act it out actually, so you can also practice how you're gonna show up on that, ne? Okay, see, I see there's a question there from Fernando. Fernando, do you want to clarify what you are talking about, the digital recordings in the court? Or is it of this session? Because I see Zukiswa said no. Do you want to make us famous? Like the Senzome US case, or what are you talking about? Fernando Rodriguez, can we leave your question, or you are answered by Zukiso? Okay. So that is that, ladies and gentlemen.
I think sorry, I think Fernando was referring. Oh, okay.
Someone was speaking, I don't know, Maxwell, or who is that? if you're not gonna speak up, guys.
Yes, I think Fernando, because his comment was, can you hear me?
Yes, loud and clear.
Maybe there's a problem then.
We can hear you.
Yes, I was saying, I
Maripoli.
think Fernando was talking about the fact that, I think maybe it's a reception issue. I was saying maybe Fernando was talking about the fact that you said about inaudible transcripts. So he was asking if you can record in court. I think he was referring to that.
No, before you record in court, you need to make an application. You need to quote the sections for the Criminal Procedure Act and state the reasons why you want the proceedings to be recorded. Yeah, so like what we are seeing with the Senzo Meyiwa trial, it's a matter that is of public interest. So it's being streamed live because people are interested. So yeah, all those things. Yes, the court normally is an open court, but the streaming of the visuals of the courtroom cannot just be done, yeah, willy-nilly. You need the permission of the presiding court to allow such to be done. I hope that answers you. So don't pull up your cell phones in the court and start recording people in court, please. You'll get into trouble with that. Because remember, there's also the sensitivities of the cases, the age of the witness, you know, things like that, that determines whether it's going to be an open court or it needs to be the proceedings held in camera. So it's not everything that must be televised, I guess, for lack of a better word. So, ladies and gentlemen, we are getting into the pre-trial stage now. So depending on who is the one who approached you as the lawyer, can happen that it's family members because the accused is already sitting in custody. I wonder how Zukiswa keeps record of you guys attendance wise. I see guest says, are there specific matters that are allowed to be transcribed, or any matter is allowed to be transcribed by application? I think it's very rude, guest, that you don't put your name on and you call yourself guest and you're asking questions. So I'm not going to answer your question. Eh? I think even if I got Malikolo's name wrong, Kwanele was busy laughing at me. I thought it's Maxwell. So please, let's refrain from not identifying ourselves. You will see as you go along with these sessions that it's important that your names are showing on these recordings, because you may have an attendance issue, and if they need to check if you were really on the session, you may have a problem with that. So please, I saw even some numbers. I don't know who is this, 2563741 something something. I mean, just ensure that you set your device to show your name, and it mustn't show an alias. We don't want to see Bojack Knife. We don't want to see Sunny Boy. We want to see your actual name that the school knows you by. See, this is where you are laughing. Yes, I see some alias here. Who is Akas? What is Akas? You know? So you're going to have a problem. I'm just warning you. Maybe I'm the first class that you have. But yeah, this is a school that keeps record, and you need to be able to be identified.
Akas is actually my son.
That's what I'm saying. Set your names fully so that it is known who you are. I'm just saying. Like you can see, we see there's Alicia van der something there. So we know that this is the person that is talking. So please just set up your device correctly, because you want to have a lot of these sessions, not only me, there's lots of instructors coming. Ne? Okay, Fine, let's move, guys. Yes, I'm refreshing. Thank you. So, guys, depending on who has approached the lawyer, it's important to establish the assistance needed by the client. Determine whether you are able to provide the help needed and the amount of time necessary to execute the mandate. You see, we are coming back to that issue of lawyers who are withdrawing in court now. Avoid taking on a matter and later passing it on in the case where it's seniors passing work down to their juniors. This undermines the confidence the client has in you because they thought Peter is going to handle the matter, and then all of a sudden Joseph is on the picture, and they were, having some good understanding with Peter, and now they have to start afresh. So just always look out for the comfort and the ease of the client. Double booking is unethical. It is also a reflection that, it reflects badly on the reputation of the lawyer. So what are we talking about here? Chances. Lawyers who are running for a quick buck, they don't want to turn down any work. You know that you already booked yourself that you will be in a particular court on a particular day. And now comes this money in your face, this client who is paying, and you now say, okay, I will, you know what? It's not too far from each other. I will first start with this one and then quickly, run to the next court. So what they do on the day, they will be calling prosecutors, please stand down my matter, I'll come after tea, and those kind of things. That is double booking, ladies and gentlemen. And the court can decide anytime from 9 o'clock to call any matter. And once the court has resumed, you cannot be certain that they will surely call your matter after tea. And if it happens that your matter is called before you are there, then you're going to have to explain to the presiding officer, where were you when your matter was called? Because your client was warned to be at court at 8:30, and they do mostly, at least 90% of the time, they do arrive at court at 8:30. And then you decided to show up around 10:30 when the matter has already been called. So that is bad behavior and bad, conduct on your part. Please don't do that. Rather, if you know that you've got colleagues, maybe ask somebody to go to the left and you go to the right. But don't try and run all the courts in one day, because it will land you in serious trouble. Ensure that the cost implications are fully explained to the client to avoid misunderstandings. We spoke about that already, about the fee agreements, especially in criminal matters, because seemingly the clients will be told at the bail stage, now you'll pay me 5,000. And then they think up until the end of the trial that will cover all the costs. Make sure that all the cost implications are broken down to the client so that they will not be caught with any surprises, and they will be fully aware of how much you expect them to pay you by when, so that you don't have those problems. We move to the first rights of the accused. There is a presumption, ladies and gentlemen, in our law that states that the accused is presumed to be innocent until proven guilty. We have spoken already about Section 35. That is the basis also of these rights of the accused. So please familiarize yourself with those rights. What I'm going to talk about here, ladies and gentlemen, it's not all the rights, but I will try to touch on some of the rights. Okay. First one is the right to remain silent. These rights, as I indicated, they kick in from the moment the accused is arrested. where a statement was made by the accused without being informed of this right on the streets, wherever they are, whether it's under Bree Street in Johannesburg, where there was an explosion, or wherever where they are found. I'm joking. I'm joking. I'm joking, guys. I'm just joking. Please delete that one. Where a statement was made by the accused without being informed of that right, it renders such information inadmissible in court. You see, it may be incriminating information, but because they were not warned of their rights, then you're going to have a problem. At the start of the trial, accused may elect to remain silent and not make any opening statements. And when the state closes its case after leading evidence, the lawyer will discuss with the client with the options that they have. If the client elects at that stage to remain silent and close the defense case without leading evidence, the court may draw a negative inference to that and subsequently convict the accused for failing to testify. This is a reality. So you need to be careful. If you want to advise your client not to say anything, you need to weigh up what kind of evidence is already on the record, ladies and gentlemen. I mean, obviously the state would have gone first in presenting the state case. So you need to have, worked out whether there is anything that calls for the accused to answer. Maureen, I think you need to mute unless if you have a question. Because, ladies and gentlemen, it's not a must that after the state case is closed, the accused must also testify. So if you weigh up the quality of the evidence that is presented, maybe you've made some applications and whatever that you think is necessary for you to make, you weigh up that, you know what, the state has no case at all. That's when you give this advice. Because if you don't properly examine the evidence that is on record, it can work in this way that now the court may see it as if this accused is avoiding to testify for the fear of, wanting to face the music when they are cross-examined, and it can also be seen that they maybe have something to hide. But if you are certain that there's nothing that the accused needs to answer, then you stand firm in your advice to your client that, look, I've assessed the evidence. There's nothing that they can hold you down to. And my advice is don't testify. Let's close the case without leading evidence and go straight to arguments. Okay. Hey, you're slowing me down now. I'm trying to read. Unknown user that we were talking about will come to your trial within a trial. And guest, I don't know what was the previous question. So guys, it's clear you will have to do the assessment there. The next right against self-incrimination. Anything said by the client or the accused can and will be used against them in court. This can be said in the streets to the police, and the police can later report it. in their evidence in court. That is what we mean. Or, yeah, that's what we mean. If the client were to testify, beware that he should not incriminate himself. The lawyer during consultation should assess the strength and the weaknesses of your client on how they are likely to testify and therefore protect the client against themselves. Warn client not to underestimate when they give their testimony or to exaggerate the course of events when they are testifying, because they will be attacked also by the prosecutor when they do that. And that will show them to be untruthful. So you assess your client, and based on your assessment, when you see that this guy, OMG, is not gonna hold under that, heated cross-examination, you tell them, look, I'm worried. I'm your lawyer and I'm asking you these simple questions and you are failing dismally to answer. And you can expect hotter questions to come from the prosecutor, and you need to be able to give answers. So you warn them, you prepare them, so that if they decide to take the stand, they know what they're getting themselves to. And you can even say to them, I'm concerned that you may not be able to make a good witness. My advice, you are not just there to take instructions. My advice is consider maybe not you testifying. Let's just call your alibi instead. Let your alibi speak, because there's no formula in terms of how you will present your defense case. If you decide the accused is not going to say anything, you can remain silent and only call the alibi witness to testify. That's your case. It's within your, you choose how you want to run your case. There's no one who can dictate that you must first start with the accused, then you call a defense witness. You have to know your client very well for you to be able to say they will be able to take the stand. So, yeah. Then the next right is the right to docket access. And this right is not available to the accused, as I did indicate earlier. When we're dealing with bail, there is no right to access the docket unless if permission is given by the prosecutor. The right to docket is immediately available to the accused after the state has declared that their investigations are complete. Once they say the investigations are complete, we are ready to set the matter down for trial. Now you have a right to demand that you be given access to the docket, because now you need to prepare for the trial. Please note, you as the defense lawyers, you are not entitled to a part called C in the docket, which contains a diary of communications between the police and the prosecutions. Here, they give each other instructions. Like the police will say, I went to this address to look for the eyewitness. They say the eyewitness does not stay there. Then the prosecutor will write back and say, please follow a new lead of, information that was received in court, that you should check elsewhere, or they may say, go and obtain cell phone records, go and confirm, collect banking records, whatever instructions is going to be communicated in that part C. So that information, it's not supposed to be for our consumption as the defense lawyers. It's meant to be confidential between them as the state. Please, if you are found to be opening that part of the diary, they can actually, accuse you of interfering maybe with their case, or yeah. So you don't want to be that guy. Richard?
Thanks, ma'am. Just lower my hand here first. Thanks. There are a couple of cases, I don't know if it's reported, but there are a couple of unreported cases. If you look at the case of State versus Panahoti in the Eastern Cape in PE High Court, where access was granted by application to access the SAP 5, which is the investigation diary. So you can bring an application, and most of the courts these days give access to the defense to the SAP 5. Thanks.
Yeah, but you'll have to have very good reason, because you know what they would ordinarily say. That's where they are communicating maybe like, these cases where they will say they have this witness who comes to court and they don't disclose their identity.
A 204?
Not a 204. The ones who go in, like maybe when they're doing a secret operation, they will tell you that, the identity of their witnesses must be protected, and also, I'll remember it. But like, even when the witness comes to court, they don't, like, I've seen a case where that witness did not enter where the members of the public walked in. They will be coming through the court cells and the court will be cleared. So the court must be in camera for that witness to testify.
Mr. X.
Ma'am?
Yeah, Mr. X, you know who I'm talking about. The one who's like a spy, but people don't know that he's a state witness. So he's feeding all the information to the state. You understand? So that is why, that information is going to be kept for them, because they will say because they maybe say, for instance, witnesses who are in witness protection and the whereabouts of where they stay. It's also something that it's communicated in those diary communications. There's cases that are sensitive, like really, really sensitive. So I wouldn't even want anything to do with diary if really it doesn't change the shape of my case, unless really there's something really, really important in that diary that's gonna help your case. For me, I wouldn't even tamper with wanting to know what they have in there. It's their business. So me, I'm expecting to see what statements have they obtained, because those are the people who are coming to testify. And if they say they have, I don't know why this word is running away from me. That witness that they wouldn't disclose who that witness is, like a surprise witness, but it's not called a surprise. Yeah.
Ma'am, isn't it the undercover agents?
Yeah, those undercover agents, because those ones, they're part of their operation, maybe they're trying to crack some indicate, like it's drugs or whatever. So normally those people are supposed to be kept, like even as they came to court, their identity is supposed to be never to be disclosed, because it's like sometimes they move from operation to operation, operation to operation. So they wouldn't want anybody to know that they are working as a spy,
Yes, ma'am. The other ones that maybe I would like to add, it's Sam here, ma'am. I wonder if you can see my name there. It's the special operatives, like your special task force. I've heard at some point that those guys are not to be seen, and they always testify in camera.
Yeah, I've seen, I think that case that I witnessed, but I wasn't doing the case. So we were all told, I mean, normally in court, lawyers are not going to be asked to go out. Like if you are a legal rep in court, you can sit in for most cases that are even in camera, even if it's not your case. But when it's those kind of witnesses, they will even tell you, please clear the court. Even the court orderly will be instructed, clear the whole court. Only the lawyers, the lawyer and the accused and the prosecutor and yeah, the necessary people must remain in court. All the observers out. So yeah, so that's why I'm saying I really don't have any business unless if your case, because maybe I haven't come across a case that necessitated me to want to go into their communications. It depends case to case. If it comes to that, then maybe you can bring those applications if you think that they are withholding crucial information that can help your case, that is communicated in that diary, and maybe you say that, how it will be assisting your case. Maybe, yeah, you can try. You can try. But generally, it's a general rule. You stay away from that diary because that's where they communicate their things. Just like you raise professional privilege, and you say my communications with my client are privileged. You can't ask to see my consultation notes. You can't ask me to disclose what I've discussed with my client in my office. Don't you think they also deserve some privacy? If it's not detrimental to your client, so that's just me, but you'll decide. Your case will guide you whether you need to go that far. Okay. Next right is the right to be brought before court within 48 hours. Purpose is speedy production. This one, ladies and gentlemen, it's not a problem because everyone is well aware of this one. Plenty of cases, plenty of memos that are circulating within the ranks of the police and the national prosecuting authorities. Whenever there's a new case that they've just been hit hard about, they always keep themselves up to date on these kind of cases that they should always observe, the 48 hours rule to ensure that they don't bring people beyond that 48 hours. So please note there that there are instances where this 48 hours can be extended, for instance, in the case of long weekends. And I can say for myself, I'm not saying it's the whole country. I know I practice within a specific region that is very, very specific. So I'm not speaking for the entire country, but I have seen how they are strict in how they apply that rule. Where the police bring someone in late, they're not even gonna place that matter on the roll. I've witnessed, it wasn't my case, but I've witnessed where the police were trying to take chances after a long weekend and they still exceeded really without any valid reason by another day, and brought the person, I think it was a Wednesday to a Thursday, I think. And the prosecutor was like, I'm not putting my name down on this one. Sorry, go to the cells now and release that person. So they refused to place that matter on the roll. So yeah, the communication is clear to them. I'm not saying it's not happening, but those who are still doing it, they are just being ignorant. There's plenty of awareness about the 48 hours rule, which they ought to know how to observe that, because there's so many cases where they've been sued for this. So yeah. The right to a speedy trial. I see lawyers jumping, saying justice delayed, is justice denied in the court. Then they're trying to say, that the trial should be allowed to proceed as soon as it's possible. But you often find that there are delays, some caused by the state, some caused by the lawyers, and some caused by the presiding officers. But the idea is we should, all of us, avoid delays and unnecessary requests for the remands, because that's how it takes long for these matters to get to trial. Now, you should oppose any unnecessary requests for postponement by raising your objection, and you have to say why you are objecting by, for example, saying the prejudice that your client will suffer. You have to say what is that prejudice. And you can mention things like, this is stress. When you have a case hanging over your neck, that is pending finalization. This time is wasted by coming to court. Your client is a big shot businessman who needs to close down his business when he's coming to court, and is losing money by coming to court, and also having to pay your hefty legal fees. Any financial loss of earnings if they keep on being away from work, that they end up not having any leave days anymore, the employer is not taking it, they're about to lose their job. Any other, reason that you may think of. State must have their house in order, and you say, what is it that is happening that's causing them not to have their house in order, and proceed to state what are those concerns that you have to object. So please note, there are many rights that I did not specifically discuss here, but I just wanted to highlight a few. You can read on in that thick manual from the school. The list is there. Check other rights. Check how you will be able to call for those rights to be, observed. If they are not, make noise, very loud noise. And I think, ladies and gentlemen, it's enough for this evening. We still have a whole 4 days to go. Do we have any questions, or can we consider this session closed for today? The love and the clapping of hands. Good night, ladies and gentlemen. I'll speak to Zukiswa to make sure that you all get the slides. So thank you, thank you, thank you. See you tomorrow. Bye-bye.
Good night.
Bye.
Bye.
Okay.
It's like a song.
Good
Bye. Like
I
a song.
had my hand up. I guess I'll ask tomorrow.
Yes, please do that. Ask tomorrow. Bye.
Good night.
I'm stopping the session. Bye.
Good night.